Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. It's good to have you with us. We have two interesting cases. And we have some guests from Virginia Military Institute. It's good to have you all here. Most importantly, we have good lawyers, and we're looking forward to the arguments. In the first case, Lowy versus Daniel Defense et al., Ms. Lockwood. Good to have you with us, Ms. Lockwood.
Thank you, Your Honor. May it please the court. My name is Liz Lockwood, and I represent plaintiffs Karen Lowy and her minor daughter, who are watching live today, and Antonio Harris, who is here with us in the courtroom, all of whom have brought suit against manufacturers of AR-15 weapons, ammunitions, and accessories based on their deceptive and misleading advertising, which glorified and promoted their products for militaristic and illegal purposes to a young man who then replicated exactly what he saw in defendants' advertising using their products. Just like he saw in defendants' ads, he packed his AR-15s in his car, set up a sniper's den across from a school from high above, looked down his scope, and targeted the cars in the pickup line. And plaintiffs were the direct victims of that gun violence. The causal chain is as simple as that. Defendants deceptively advertised their products for illegal purposes in violation of various laws. Those violations were a cause of the shooting that followed because the shooter used defendants' products for the same illegal purpose they promoted. And plaintiffs.
So, I mean, when you think about it, you're talking about a group of ads by different entities, and you say it caused this injury. What specifically, and is it, because we're at a 12B6, we're at the motion to dismiss stage, and I realize a number of things you have there alleged upon information and belief, but what specifically do you think you're going to need in discovery to be able to establish that the defendant caused this injury?
Well, proximate cause requires that we show that the defendant's actions were a cause of the injury. And there's a number of avenues of discovery that we expect to explore, some within defendants' possession, information related to where they placed their ads, who they were targeting, the breadth of their reach, but also plenty of information not in defendants' possession. Social media companies, their tracking of the accounts' various advertising, the online websites where the shooter purchased many of these products, the advertising he was exposed to then through that channel, third-party marketing consultants who would have assisted defendants in creating these campaigns and promoting them. So there's a number of avenues that we intend to explore during discovery. And to get back to the question about what we need to prove, here the district court dismissed our 80-page complaint in an 11-page order based on Article 3 and proximate cause grounds, which obviously require.
That would be under 12B1.
That's right, Your Honor. I was just
lack of standing.
That's right, Your Honor. And I was talking about the causal chain more broadly.
But before you can get to 12B6, you got to get some way past 12B1, right?
That's right, Your Honor. And 12B1 at this stage requires, depending on the way the court wants to look at it, either a determinative or coercive effect or a predictable effect. And we've certainly, no matter which lens the court takes, We have
It's
adequately
kind
alleged.
of hard, I mean, that's a pretty, if we're looking at those two alternatives, I mean, I know you say you make both of them, but I don't see how you have pled, and quite frankly, I'm not faulting you on that. I don't know how you could plead determinative and coercive. I mean, just the nature of that requirement, when you look at the cases that have found it, it just seems to me like that if that's the question, you face an extraordinary hurdle to show that.
Well, Your Honor, at the pleading stage, Article 3 standing requires something less than what the district court found it required here. So the district court interpreted determinative or coercive effect to require allegations that the defendants coerced the shooting.
Well, determinative and coercive effect, I mean, it's not influence, it's determinative and coercive just by its very words. And the cases that have done it, like Bennett, and there's a Ninth Circuit case that applies it and finds it when there is almost a legal obligation. There's a homeowners association case we have here in the Fourth Circuit that does that. I mean, those are almost, legal requirements to do something. And it seems like your theory is that, there are folks out there who are potentially vulnerable to these ads, and I hear that, and accepting that as true, I'm just seeing how that, even if it's true, could ever rise to determinative and coercive. Now I get your argument that you got a different standard, but it seems to me if you get that standard, you're facing a problem. I don't see how you can do it, discovery or not.
Well, Your Honor, I think if we could look at the allegations that we've made, and especially focus on the imagery in the advertising, in these campaigns, which the shooter went out and replicated in sort of a stark fashion.
Sure, listen, your theory, that influence team, I want to do that. That's not determinative and coercive. I mean, he wasn't hypnotized. I don't mean to make light. This is a horrible situation, so I hope I'm not trying to suggest otherwise, but it just seems like your allegations giving them full acceptance wouldn't establish that. It seems like you have to argue that's not required.
Well, Your Honor, if I could try one more, I can try one more time. I can give you some JA sites where we cite the influence that had on the shooter, and then perhaps we can talk about the predictable effects and why that's an alternative. But, at JA 70, 71, 72, 48, 49, 60, 61, we talk about the imagery that's replicated. At JA 81, we talk about how the shooter has perceived these weapons to be superior, that he selected these and brought them to the location.
Assume I think, and I appreciate I read all that, and I think you're making as good argument as you can about that, but assume I'm hypothetically not convinced that you meet that standard. How does the Department of Commerce case, how can we read that to change the standard for standing?
Yeah, I'm not sure the court necessarily needs to find that it changed the standard. It is another lens to look at Article 3 standing. And the Department of Commerce case looked at, in a similar situation to what we have here, whether there was the defendant's conduct had a predictable effect on a third party. Defendants claim that this case doesn't have any application here because Department of Commerce was about injunctive relief. But we've cited two other cases.
That doesn't seem particularly persuasive to me, because an injunction case, is by its very nature predictive, but it's predicted of likelihood of success. So you still got to deal with whatever it is. It seems to me that case is different. The issue with that case is we've got a jury or a bench trial, and the nature of that case is that the census question could cause some people not to fill out censuses, and there was evidence that that was the case. So you were talking about a broad policy that just had to have some effect, whereas here we have to have an effect on a particular, individual who purchased these, these firearms and weapons. So I just wonder if the better argument on standing for you is, that we haven't all these cases are administrative law cases where we're looking at this determinative and coercive effect. And I just, applying it in a tort context like this seems odd. I mean, like I said earlier, I don't know how you would ever show it. And I just, it would seem if that's our standard, you just can't do it. And I wonder if we're not making traceability here too much like causation. And, maybe we get the same result on causation, but it feels like standing is becoming too much of a merits question.
Well, Your Honor, just to address your point about the.
Your position basically is we got to take your complaint, the allegations of your complaint, as true.
That's absolutely right, Your Honor. And
Accept them as true.
And
go from there.
That's absolutely right, Your Honor. And
that's enough.
Article 3 might require more. Of course, it requires more as the case goes on. But at this stage, it certainly does not require that we show that the defendants coerced the shooter. And the predictable effects test has not only been applied in cases where you're talking about adjunctive relief. We cite a case out of the Second Circuit in our opening brief, page 27, the Ateres-Baez case, where this was about injuries that had already occurred. It was a damages case. So I don't.
Much of what Judge Qualibon's saying, it seems to be on point, more so from my perspective at a summary judgment stage. And where Judge King is leading you, at least what pointing to, is the fact that, all of that may well be true in terms of establishing standard, but you don't have all of the critical information that you need. And how would you in these cases? You can't get it from law enforcement. You can't get it from other places. You actually have to go through discovery, which is why I started out by saying, what can you get out of discovery from this? And it may well be that when you get to summary judgment, that impossible or that incredibly high hurdle that Judge Qualibon describes may be there, but where we are now, we're just not there. And the question is, did you actually plead the coerciveness? And at least from your complaint, you seem to indicate, or at least you indicate pretty clearly, there's an increased level of violence. So then when we're trying to connect what's here, your allegation, advertisers make guns and component, all kind of parts and stuff, and they say, and then they advertise, if you put these things together, you can do this with it. Even showing it from your perspective in a light most favorable, not what would be actually proven at trial, that, in a school setting is where you could be. You could be perched up and showing people with a gun, and it is remarkably similar to what happened in this case. A young man goes up, purchases himself just like in that ad, shoots into it, and cause all this horrific damage. Again, I think that if you progress to the summary judgment stage, and then that's where we get muddled with 12B1 and 12B6 on it. But I think in terms of being able to get there, you've got to have the critical information. Again, why I pose the question, what do you get out of discovery from this matter? And it seems to me, even in cases like this, a trial court could easily just say, okay, let's move a little further along so I can consider some evidence. I can consider the stuff that jury ultimately may not be in your favor, may be in your favor.
Yes, we agree. And I should just point out that the district court dismissed our information and belief pleadings based on.
The district court criticized you for pleading on the basis of information and belief. And you did plead on the basis of information and belief, which is entirely proper with a pleading. And those pleadings need to be taken, well-pleaded facts, taken in the light most favorable to you. In the 12B1 context, assessment on standing. That's your position.
Yes, Your Honor, and I think we're on the same page about the permissibility of those information and belief pleadings.
So
But
counsel,
the district court was wrong in discussing your use of information and belief in your complaint.
It was wrong in how it dismissed the allegations as improper at this stage. So I think we're on the same page about that.
Well, it did, but there's one point it made that's kind of interesting, and that is that it's only appropriate information when that information is held by the defendant themselves. That's an interesting point. I don't know of any case court has held that you can only plead with information and belief if the information is held by the defendant themselves.
I'm not aware of any case who said that's the only route where it's permissible. It wouldn't make any sense for that to be the case. In recent decisions from this court and Vaughn, for example, the courts reiterated the appropriateness of this type of information and belief pleading. And, there are certainly circumstances where the information may only be in the defendant's possession, but there are plenty of circumstances where it would be in other folks' possession, as Judge Wynn, you were highlighting, and as one of our amicus briefs highlighted as well.
So, counsel, could I follow up on this? I think it's a very fair point that you can only plead what you can plead at the 12B stage. I mean, we wouldn't want you to say upon information and belief and just make stuff up. That would be that can't be what you do here. So I appreciate the fact that at this stage of the case you haven't conducted discovery. But how do you deal with a case like Iqbal, which dealt with national security stuff and things that were also hard to get, maybe even in discovery? And it seems like that case at least says, sometimes it may be harder than others, but, the plausibility standard, now I know you think you meet the plausibility standard as you've done it, but, it seems like it's not like we can say, just because you can't get it. Iqbal tells us, hey, by the time you file a complaint, you have to have enough to meet that standard.
And we have far more than the sort of bare pleadings that I think, were at issue there. We don't just have a collection of allegations on information and belief. We critically, which we know is necessary, have allegations which make those information belief pleadings far from speculative. So we allege that at JA 81 on information belief that the shooter was exposed to and influenced by their marketing practices. Those allegations are backed up by the advertising that we highlight with imagery very close to what we have.
Can I interrupt you? Because I just on that point, didn't you just plead yourself out of determinative and coercive? You said exposed to and influenced by. Even if that's true, isn't that by its very nature short of determinative and coercive?
I don't think so, Your Honor. That's one paragraph out of our 88-page complaint. And against the context of the force of this advertising, the fact that the shooter selected these products out of a larger collection of products and then brought them to build his cache of weapons and carry out the shooting is all part of the causal chain here. So I don't think we can look at that allegation alone. And I see that I've exceeded my 17 minutes, so I'm happy to save the rest for
As
rebuttal.
long as you have questions, you should answer them. Go ahead.
Can I ask one more question? Moving from standing to the merits, were we to get there? Do you have a case where Virginia courts have applied the two Virginia statutes that you pled in a case where the plaintiff wasn't deceived?
Yes, Your Honor. So, I'll remind the court that both of those statutes are broad remedial statutes, but
What's the case you had?
Merriman v. Auto Excellence is under the Virginia Consumer Protection Act. And I don't have the cites here for the false advertising statute. I'm happy to get that on rebuttal. But those issues were briefed below. Defendants did not raise that as an alternative basis for affirmance, and so we don't have focused briefing on those statutes, for Your Honor. And there's other claims, of course, that we have here, the negligence and negligence
No,
per
I
se.
understand. I'm asking about those two
okay.
specific, but you have a situation like there where that was not, that Virginia law has interpreted those to situations where a plaintiff isn't saying, I'm deceived by the ads, because your claim here is that this plaintiff wasn't deceived by, false advertising or, misrepresentative advertising. You're saying that it was very accurate and that this defendant took it the way you said it was going to be. Do you have a case where those statutes have been applied in that
So
context?
that statute recognizes that the Virginia Consumer Protection Act only requires that misrepresentations be done in connection with the consumer transaction. This is a statute that permits a suit by any person, and I believe that case did involve a downstream purchaser
okay.
or someone who was not a part of the misrepresentation itself.
Thank you.
Let me ask you one question. What exception under the PLCAA do you think your common law negligence claim falls under?
The common law negligence claim, Your Honor, is pled against the magazine manufacturers who we've argued are exempt from PLACA. And so the common law negligence claim would proceed against them if the court were to accept our position that magazines are not qualified products under PLACA.
Okay, thank you.
If there are any,
Make sure I understand that. So what you're saying, the exception, maybe tell me if I'm restating this incorrectly. You claim that the magazine suppliers, manufacturer suppliers, aren't covered because those aren't component parts, and therefore you would be able to proceed on that basis.
that's right, Your Honor.
As opposed to, okay, it's an argument that the act doesn't apply to them as opposed to an exception.
That's right, Your
Okay.
Honor. If there are any further questions, now I'm happy to take them or reserve the rest of my time for rebuttal.
Thank you. You've saved some time.
Okay, thank you.
Mr. Barnes? Mr. Barnes, good to have you with us, sir.
Thank you, Your Honor, and good morning, Your Honors, and may it please the court. This case is not about whether the products that defendants sell ought to be illegal, and it's not about whether media that portrays guns in a positive light in general has the effect of increasing gun violence in general. Instead, what this case is about is whether 52 specific social media posts caused a specific shooting in the District of Columbia. To meet their pleading burden under Iqbal and Twombly, plaintiffs needed to allege that their injuries would not have occurred but for the particular posts that they sued over. But the complaint fails to allege facts to make it plausible that the shooter even saw these posts,
How would
much
they
less
do it?
that he
How
influenced
would
them.
they get the information to be able to allege those specific facts? Granted, those facts ultimately will be necessary at some point in a trial, but at this stage, where you have such an horrific act, they have the ads themselves depicting at least what they characterize as being similar type things. They are saying those ads are directed to transport the military type tactics and war tactics to civilians and targeting specifically young men out there. At this stage, without having any other information, how could they do that? Or is that possible to do that?
I think it is possible, Your Honor. I have a few thoughts on that. First, it's clear enough from the allegations in the complaint that the plaintiffs could have sued the shooter's estate, and as part of that proceeding, they could have gotten discovery. Second, it's also clear.
Let me understand that. You sued the shooter's estate for wrongful death or injury, the negligence of that nature, and as a result of that, you will be able to determine what against the ads?
I think
the manufacturers here?
As part of that proceeding, it would be possible for the plaintiffs to get discovery broadly, I would submit, into sort of the surrounding circumstances of this shooting and the shooter's
I assume
behavior.
you're assuming the estate is going to then bring in the defendants and say that, so as to indicate a lesser form of culpability of negligence on their part, so that someone else is responsible for his conduct.
I'm not
Because
necessarily,
of going against the estate directly, I'm not getting that unless because they are not alleging that this is a coercive type action. They're not alleging against the shooter himself for doing it, which you could. I mean, that seems like a clearer situation right there, but not on this basis, not a case of this sort.
well, I don't think I'm assuming any particular defense strategy by the estate, but what I am assuming is that as part of that proceeding, it would be possible to get discovery into the surrounding circumstances of the shooting.
I'm curious because, thinking, I didn't litigate as recently as Judge Quattlebaum here, but I did spend a little time in trial work, and I'd be interested as a lawyer. I'm suing an estate. How am I going to get that information that you say would be critical in establishing standing in this case? Who am I going to ask that, and what am I going to say? Just give me a off the top of your head answer. I'm going to accept it.
Sure, I think it would be the same people that opposing counsel rattled off that she suggested that the plaintiffs would submit third-party subpoenas to in this case. I think they could issue those same third-party subpoenas in a proceeding against the estate. And I don't think it would particularly take that much because
You
basically.
could also, if the theory is this particular defendant is particularly vulnerable, you would have that, and the party that would have that would have that direct information. You're not even going outside to third parties for that sort of information, right?
I think that's exactly right, Your Honor. I'll point out.
Was this
that
case filed, is a 2-year statute of limitations in Virginia for personal injury cases?
I think that's right, Your Honor. I
And this
confess that.
case was filed a little over a year after that incident?
I believe that's correct, Your Honor.
Is there, does Virginia law, some states allow for pre-suit discovery? Do you know if Virginia permits that?
I don't know the answer to that, Your Honor. Let me make another point or suggest another way that the plaintiffs could get some of this information, which is that actually, victims in a high-profile, terrible shooting like this, they have access to, in some ways, more information than plaintiffs typically are going to be able to have access to pre-suit. There's an extensive police investigation, there's extensive media coverage.
I thought they wouldn't give it to them.
Yeah, they filed a FOIA
couldn't get
action.
that.
so-
They did, and I would encourage
Their
the court.
position is that they have standing on this complaint. That's their position, and that the district court erred in dismissing it on 12B1. Isn't that right?
That is right, Your Honor.
And if the district court dismissed it on 12B1, the district court didn't have any jurisdiction to address the 12B6 issues at all.
I also agree with that, Your Honor. I think
You
that's
agree
right.
with that?
I do. I think the district
You
courts.
agree with me?
Yes, I do,
There
Your
was
Honor.
no jurisdiction to address the 12B6,
Our position
based
is,
on the face of the opinion of the district court.
that's
And that
right.
goes back to Ex parte McCardle. Do you remember that one?
Vaguely, Your Honor, from law school. It's been a minute. but,
That's, yeah, Salmon Chase. Yeah.
Right.
Once the court's without jurisdiction, they can't address anything. So on your position, the district court's opinions with respect to that act, whatever you call it, which is a big acronym,
The PLCAA.
are all, what, advisory, dicta? What are they?
In defense of the district court, I think it was reasonable for the court to explain its views and the alternative.
But the district court ruled that there was a lack of standing. That's no jurisdiction. Standing is jurisdiction. Federal courts have to have jurisdiction. The federal judge has to have jurisdiction. I mean, we've got, for a court to pronounce upon the meaning or constitutionality of a state or federal law when it has no jurisdiction to do so is, by very definition, for a court to act ultra vires. That's outside the law. Now, that is from Justice Scalia back in around the turn of the century. So under your position, everything the district court said about the statute, the act, is ultra vires, because you say that it was properly dismissed for lack of standing. So that's out. So,
I don't disagree
So,
with Your Honor's characterization of Article 3 standing. Let
so
me
if
say,
if I say there is standing, I disagree with you on the merits of your ruling. What would I do with, then I'd have to address what the judge did on this act as well?
I think that's correct, Your Honor.
He ruled on all this stuff without any discovery being conducted, on all the issues relating to this new enactment that the Congress came up with, when he didn't have any jurisdiction.
And let me say one word in defense.
Based on your argument, he doesn't have any jurisdiction.
That is our position. That
Your argument is he had no jurisdiction to do that, but so then if I decide, or were to decide, that this ought to be reversed on the 12B1 aspect of it, then I would also need to vacate everything after that until some judge had an opportunity to study it further.
I don't think that's right, Your Honor. We've raised.
well, it's ultra vires you just agreed with me on, according to, and ex parte McCardle, going back to the middle of the 19th century, a court without jurisdiction can't rule
Let me make 2 points.
in this country, in the federal system. That's what it says. A court to pronounce upon the meaning or the constitutionality of a state or federal law when it has no jurisdiction, by very definition, is to act ultra vires.
So everything about this act is ultra vires on the face of it, of what the district court did here. It made a 12B1 ruling and then proceeded to make a 12B6 ruling. But the 12B6 ruling is ultra vires because the 12B1 ruling was in your favor. He can only rule on the 12B6 if he gets past the 12B1 and found there was standing. So there you are, and I'm just trying to figure out what I'm supposed to do. If I think there is standing, what I'm supposed to do with the part of it that's was considered under 12B6.
Your Honor, could I make 2 points?
You can, absolutely.
Okay, so the
Make
fir-
more than that if you want.
the
As long
first
as you got time, you can make all the points you want to.
The first point is that it's very clear under Fourth Circuit precedent that we, as the appellees, can raise alternative grounds for affirmance. And so if the court is persuaded, not without regard to whether it was proper for the district court to reach the 12B6 issues, if the court is persuaded that there was standing, then it is totally in bounds for us to press alternative 12B6 grounds for affirmance of the judgment of the district court. That's the first point. The second point I would make picks up on something that I think I heard Judge Quattlebaum say during one of the colloquies with my friend on the other side, which is that to the extent that the court is persuaded that for some reason this coercive and determinative effects test is not the right test, or we're demanding too much of litigants on standing and causing traceability to collapse into what should be a merits inquiry into causation, the same reasons that the district court gave for why it thought there wasn't traceability under Article 3 are equally a justification for affirming on 12B6 grounds what the district court did.
Counsel, would that be the case, the district court, the district court does find no jurisdiction and then does go and address the merits, and Judge King makes some interesting points about that. But just looking at what the district court did on the merits part of it, it was all under the act, right? It said first that the magazines were components, and second, didn't deal with any other merits parts of the acts, but said you got to show, if you're going to show a violation of statutes, you got to show those violations proximately caused the injury, and said there was no proximate cause. If you just forget the act for the right now, don't all those claims on the merits, aside from an immunity under the act, require proximate cause? I mean, certainly negligence and negligence per se do, correct?
That's correct, Your Honor.
And even the consumer, the advertising and consumer protection claims, I mean, whatever misrepresentation you allege, that is alleged to have happened, has to have caused the alleged injury, right?
That's also correct. I think Virginia law is crystal clear on that.
So is there any difference in the proximate cause argument that the district court did under the act that would be any different from proximate cause under the merits of the 4 causes of action?
So I think the tests for proximate cause under Virginia law and the PLCAA are meaningfully different.
Okay, could you help me with that?
Sure. So the PLCAA, we read to impose a federal directness requirement.
A federal what?
A directness requirement, whereas under Virginia law, as I understand it, the inquiry focuses more on foreseeability rather than directness. I think the result in this case, based on the allegations in the complaint, is the same, irrespective of which of those 2 standards the court uses. The district court's opinion, it does rule on the basis of the PLCAA as it reaches the 12b6 issue, but it also draws on Virginia proximate causation law. And so I think it's, and I think the district court did that for good reason.
How can they rule on the act, and how can you all even talk about ruling on the act if there's no standing?
Well, I don't think there.
You say that the judge is right, there's no standing, so you throw the complaint out. And the law is that courts can't give advisory opinions. They have to have a case.
And
You have to have jurisdiction.
And Judge King, I
You
think.
can't pronounce on the law if you don't have jurisdiction.
And Judge King, I think that may be a fair criticism of the district
And
court's opinion.
standing is jurisdiction.
Correct. And that may be a fair criticism of the district court's opinion. It's not a reason that these 12b6 issues are not before this court
Well, it
as part
is.
of this appeal.
It is. He ruled there was no standing,
And
first and foremost.
The court ruled there's no standing.
That's correct, and I'm pressing the
And then he
12.
said, but here's what I think about this act. And he ruled several other pages of what he thought about the act. And that is what they call dicta or advisory. It's without, it's just telling the public what he thinks. He could have made a speech or written a law review article or something. But the court to act with effect, as Justice Scalia said, to pronounce on the meaning or constitutionality of a state or federal law when it has no jurisdiction to do so is by very definition to act ultra vires.
And again, I'm here pressing the 12b6 arguments as an alternative ground for affirmance, and I don't understand my friends.
Your point being is that where we are in the proceeding now, if we take Judge King's point, that only 12b1 is before us, if we rule in the favor, that's the end of it, we go against it, goes back to the court, saying, no, you did have standing jurisdiction and therefore proceed. And pretty much he's already done that. It's before us, so as a judicial economy, we probably, the point being there is there. But let me ask you, in response to one of the questions you had with Judge Quattlebaum, regarding the negligence per se exception, that does not have a separate proximate cause requirement. So is that not different than the other claims?
So the statute doesn't use the words proximate cause when it refers to negligence per se. We read the reference to negligence per se as carrying with it necessarily a proximate cause element, because that is, I think we cite maybe the Dobbs treatise on
So you have to
torts.
read something that's not in the statute. In other words, you think there's something about that statute that textually is not telling you what it is saying, just doesn't have it. In other instances, it does. And typically, when we have those kind of juxtapositions in a statutory context, we don't read into it what might sound be reasonable, might be something we do, but it's not what's in the text. You know, that's kind of where we're going with this whole business of looking at the text of what's there and what's there. But at least from that perspective, if we get there, it does seem clear that at least from a textual perspective, negligence per se does not have a proximate cause requirement. You do agree with that?
I agree that the statute doesn't use the words negligence, or the statute doesn't use the words proximate cause in reference to the negligence per se claim. This is a traditional common law claim, however, that is one of the sort of inherent elements of negligence per se, and I think it's undisputed.
This is a tort claim, and we establish, I'm a little dated in all this, but my understanding of negligence per se is that it deals with the duty and breach components of a negligence cause of action. If you violate a statute, you have violated a duty. And that gets you to the third cause of action of negligence, which is causation. Now, the statute that you violated may or may not have causation sort of stuff in it, but the question is whether you violated the statute. And then you apply it within the context of tort law.
I agree with that, Your Honor. I think that's the right way of thinking about negligence per se. I
want to go back to standing with you. And, to the questions I asked earlier, we'll see where it goes. But I think the plaintiffs, have a very difficult time with this determinative and coercive standard if it applies. And maybe we got discovery issues, but I just think that's an extraordinarily high burden. And I just want, most of the cases where that comes from are administrative law type cases, or at least as I understood it. And, I just wonder if we're not, collapsing Article 3 standing into the merits in a way that we shouldn't be doing. I mean, the plaintiffs here were injured unquestionably. And, it's a traditional legal injury. It's traditional legal claims. They may be strong, they may be weak, but they're traditional sort of legal things. And standing, I get the, traceability part of that, but it just feels like we're pulling something that applies in a administrative context in a way that's effectively the same as proximate cause. And it's like standing has become the tail that wags every dog.
I guess a couple of reactions to that, Your Honor. The first thing I'd say is there are cases that apply this rubric in the context of private party litigation. I don't think there's any authority for the idea that this test is limited to cases involving the government or administrative law. Second, even if the court were persuaded that for some reason the normal standing test shouldn't apply here or should be relaxed, I think you end up in the same place on 12b6 grounds where they just haven't pleaded enough facts in the complaint to establish that the shooter saw these ads.
And that is the fact so much is here on information and belief, the district court's treatment of it. The ultimate determinative question here, and Judge Qualbaum seems to go, I'm not sure to the extreme that, well, you just can't do it. I don't care how bad the ads are. And here, they're alleging these ads are really, really bad. I mean, you couldn't imagine that a gun company could put together a series of ads, target 5-year-olds and say, go look throughout your house and find mom or dad's gun and then shoot the first person you see over and over. And when a 5-year-old does it, not to think that there ought not be something there. There is such a thing as false advertising. And that's the point here. That takes it in another level. That's where the Virginia statutes that come in and you're dealing with the predicate type offenses here. And we get back and forth. But if we launch out in terms of the separateness and the remoteness of it, we can say, oh, no, those are just ads. We don't even know if he saw him a whole bit. Boom, he did it. And we can spend all day long talking about traceability and the whole bit, but we're at 12B6. And all that seems to be here is there enough, if you take it as true, that's here, that would allow them to go to the next stage in this case? No one has said anybody's going to win or lose this case one way or the other. It's quite a burden for the plaintiffs, I think, beyond this to go there. But the question is before us, when we deal with Judge King's initial concern dealing with the standing, intertwined, I think, unquestionably with when you get to Article 3 standing, you got to go somewhat to the merits on it. You got to deal with on a case like this. But the question we have here that's before us is when you say there's just not enough facts, then that tells me, well, how do you get the facts? And you gave me some examples. You said, go to sue the estate, go do that sort of stuff. I'm certainly going to ask the other side how they would do it, because I want to know how you do it too, because a lot of generalities are thrown out that, well, you can ask, you can get it, you can do this. But when you get into litigation, that stuff doesn't leap out of the pages as easy as it sounds in an estate action against which I've done those cases, and I'm trying to figure out how you get it. I would like to have known how to do it, but it would have been interesting. So I think at this stage, what you've just highlighted there is the factual basis. Is it enough, and what do we do at this stage, and where is it a matter for the courts to take into its hand that as a matter of law, we're going to end this right here when it's an information and belief type thing, and whether that information and belief, even if you show it, do you have to forecast the evidence or something like that? And I'm not sure at a 12B6 you have to, but at a summary judgment stage, you may be in a different ballgame.
I see I'm over time. If
Sure,
I could
yeah.
just quickly
As long as
respond.
you get questions,
Okay, Your Honor.
just
So-
answer them best you can.
So just quickly through 3 points. First, I'm not here to argue that there could never be standing in a case like this.
Then not to argue what?
I'm not here arguing that there could never be standing in a case like this. I'm here arguing that the specific allegations in this complaint are insufficient to
And that's
establish
what we're
standing.
faced with.
That's correct.
Are the allegations sufficient to
And-
get past
And as,
standing to sue?
as to that
And the
question,
district court said no, and this is on appeal.
that's correct, Your Honor.
And that's 12B1.
And as to that question, I would encourage the court to take a look at an opinion from the Fourth Circuit. I believe Judge Wynn wrote the opinion a couple of years ago, Langford v. Joyner, which talks about the general rule against group pleading. My friend on the other side points to allegations in the complaint that say the shooter generally saw all of the posts that are at issue in this case generally in one place or another. And that type of group pleading is really problematic for a reason, and there's a reason that the court generally doesn't permit it. And it's worth for a moment focusing on the allegations as to one of the defendants to see why. Think about a single defendant here, TorqueMag. TorqueMag is a defendant in this case because of 2 Instagram posts, that both of which were over a year stale at the time that the complaint or that the shooting happened. And between the 2 posts, they generated less than 150 likes. Is it plausible that the shooter saw either of those posts? I would submit, based on the allegations in the
But
complaint,
what you're
that it's
doing,
not.
when you're saying that, I just want to understand that example. I mean, you're going specific, which, I get that point, but then you're saying, did they plausibly plead, which sounds like you're back in 12B6, maybe, and I think standing, I may be wrong, they just have to show standing as to one?
I don't think that's right, Your Honor. They're
You don't think-
seeking damages. They're not seeking an injunction.
I got
So
you.
they've got to establish standing individually with respect to each of the 14 defendants that are up here on appeal.
Give me an example of, hypothetically, how in a case like this, a party would plead standing under determinative and coercive standard, if that's the standard.
So I don't know if it would be possible or not, Your Honor.
You
I'm
just
not-
said you're saying they can't. I'm trying to see, what would they, in your mind, have to plead to satisfy standing if the standard is determinative and coercive?
Sure, so I think we
Nothing
did,
would satisfy you, right?
well, I'm going to be arguing for the defense regardless.
That's right,
but-
you're on the other side.
But I guess I'd point Judge
You're not going to be
Quattlebaum.
satisfied whatever they say.
I think a hypothetical along the lines of what Judge Wynn suggested a few minutes ago might be sufficient if we were talking about.
I can't recall, remind me what that
That
would
would be
be.
a close one. You do an ad that puts up to a 5-year-olds and tell them how to go look through the house and find a gun to shoot everybody in the house, and they do it. Someone does it. That would be a close one. That'd be hard for even Judge Quattlebaum to argue against.
Why would that? I mean, as horrible as that would be, it seems to me you're having to show under that standard that ad not just caused the person who saw it to say, yeah, I'm going to go do that. You have to show that the ad in a determinative and coercive way did that. It would seem to me you'd have to show ads that were very suggestive, maybe these, maybe like that, and you'd have to have specific information about I consider like an eggshell plaintiff, an eggshell purchaser.
I think that's probably right, Your Honor, and I guess I'd submit cases like this ought to be hard to plead. And the reason I say that is just the idea that a handful of posts on the internet picked out among the ocean of media that's out there in the world and I would encourage the court, look at the specific ads and media posts that are in the complaint. This is not anything like the hypothetical that Judge Wynn was talking about a moment ago.
But it does slide us in standing into questions that maybe are jury questions. And because you see these facts as being as using even this determinative and coercive, there are predictable effects that can happen. There's a level of predictability that one can reach, and of course, then that's when it gets into the soft area of it is what the court says it is. You don't really have a definition of determinative and coercive to the extent that we can use nice words to get there. Then when we get in the uses of the facts of it, we then do the weighing, even though we can call it a legal conclusion, it really is a jury question when you get down to it. And so that's why we're having difficulties here. If we lock ourselves in on terms and define them every time a case comes by the way we feel about it, it lacks the kind of certainty in terms of how we do these things, because there is a predictability of effect. I mean, if you do certain things, it's not hard to figure out if you do this, then at least that's the whole point of false advertising. I mean, that there is a great, of doing things to say, I mean, it could be say, well, I'm going to advertise this, that if you drink bleach or something like that, I'm not trying to pull anything in it, that you'll be cured of cancer or something like that. And that's not true. But it may have the determinative effect, and the coercive effect doesn't say you coerce them, but it certainly has a predictability effect.
Well, and it could be determinative, even if it's not coercive. But I guess, one thing I'd say here is that these kinds of hypotheticals that we're talking about are nothing like the posts that actually appear in the complaint. The posts in the complaint are mostly guys wearing camo holding guns. And the idea that this particular set of 52 posts, mostly on Instagram, not the rest of the media out there in the world, not all the movies that glorify gun violence, not all the images of soldiers holding guns that you could find on the news or anywhere else, none of that. But that this specific set of 52 posts on the internet caused the shooting. That's their burden to plead under 12b-6, and they haven't done it.
I think we understand your position.
Thank you, Your Honor.
Thank you, Mr. Barnes.
Ms. Lockwood?
Start with that point that Judge, that was brought out earlier by your opponent. You could get all this by filing an action against the estate. You could discover and find information that potentially would give you the requisite traceability information, or information that would say is determinative and coercive, based upon the facts that you can get from that. And why, if so, then did you, or why didn't you do that?
Yes, Your Honor. I don't think that's a realistic path for filling the gap here that we have used information and belief pleading to fill. And that's because, of course, proceedings like that take time and would cause statute of limitations, on the other hand, for a suit like this. And also, it's not, someone mentioned the FOIA suits earlier. That's kind of your best avenue for getting information, unless it's a shooting where the police voluntarily disclose information.
But your
which does-
FOIA, but your FOIA information is all about other manufacturers, it looks to me. As I looked at it, it was primarily in seeking the identification of suppliers of weapons and ammunition. Maybe I'm wrong there, but again, I keep beating this horse because I feel like that's what the standard requires. It seems to me the key issue is what was the status of this purchaser? What was the psychological, medical, mental health, things like that? And that's not in your FOIA request.
Actually, Your Honor, we have outstanding FOIA litigation, ongoing FOIA litigation against the FBI, which has access to the shooter's computer.
But is that in your FOIA, is that in your FOIA pleading, seeking that type of information?
We have, I'm not sure which pleadings you're referring to, but
Yeah.
we have requested that type of information
Okay.
from the FBI, and it's been withheld from us. We're in ongoing
I appreciate it.
litigation.
Thank you.
So I do think that that's a path where possibly, you could obtain information about the shooter, their methods in planning this, and electronically, certainly what they were exposed to. We filed that litigation, or, we issued those requests over 2 years ago, or 3 years ago.
Have you attempted to determine whether the shooter was on Instagram, Facebook, and X?
We were not able to determine based on, the information that we had. Sometimes what happens is these shooters sort of delete their history before a shooting happens. So
Right.
I'm not sure that tells us anything one way or the other. I did just want to address two things quickly. Your Honor, you'd asked about the false advertising
Yes, ma'am.
statute. And that statute requires that there be an advertisement made with intent to sell that contains a misrepresentation and that plaintiff suffered a loss. So it does not itself have a requirement that that the person who's suing be a part of the consumer.
But just talking
transaction.
about a misrepresentation, and you're not alleging a misrepresentation. You're alleging an encouragement to do what the ad says.
Well, we're alleging deceptive and misleading advertising, and so that's part of that. But Your Honor, there's a EDVA case, BHR Recovery 355 FSEP 3D 416, which addresses sort of the scope of the false advertising statute and may be helpful to you. And then also on the and I see I'm over time, so, but on the proximate cause issue quickly, counsel mentioned the direct requirement under federal law. That standard has been applied in cases like RICO, Clayton Act, where you have concerns about derivatively injured plaintiffs, where it's difficult to apportion damages. It's never been applied in a PLACA case. And there was a question about the proximate cause standard and where it comes. I agree, negligence per se under Virginia law requires proximate cause, but through the foreseeability lens that the district court used here, there's no basis to take to the extent there is a higher federal proximate cause standard, there's no basis to read that into the statute. And instead, the statute suggests that, it's a lower standard, that foreseeability is the right lens to look at this. PLACA's text, the product liability exception, refers to harm resulting directly from a product's uses, things being the sole proximate cause, and that language is not in the predicate exception. And I see I'm over my time. If there are any further questions, happy to address them. Otherwise, we request that the court reverse the district court's decision. Thank you.
Thank you very much, Ms. Lockwood. And we'll come down and greet counsel and then take a brief break and then come back to hear the next case.
This honorable court will take a brief recess. Appeals for the Fourth Circuit.
You may be seated. In our next case, it's Bermeo versus Andis. Ms. Hortachek. Did I mispronounce that, ma'am?
Pretty close.
Good to have you with us.
Thank you. May it please the court, my name is Melissa Hortachuk on behalf of the plaintiff appellant Diane Bermeo. This case is not about a suspect's confession. It's about a victim's recantation that was extracted through deception and pressure. And the district court relied in error on its own interpretation of an audio recording that the defendant submitted outside of the pleadings. And in doing so, it effectively performed a summary judgment fact-finding at the pleading stage. And in the court's order, in fact, on JA 135 in footnote 7, Judge Urbanski makes a comment about his decision would be the same under Rule 12b6 or Rule 56 because he believed that no reasonable jury could find that Ms. Bermeo had been coerced. I recognize that opposing counsel had submitted a series of alternative arguments. These were all briefed below, and they are addressed in ECF 68 in the opposition brief that we filed on January 11th. But all of those, we are maintaining that all of those arguments are still subject to the threshold issue of whether or not this was a voluntary statement or a coerced involuntary statement. That all of the existing claims are still arising from that, which is what the district court found, and we have not disputed that. I did include 2 cases. I filed a 28J letter just on Friday night. I apologize for the last minute submission. The purpose of these cases were not so much from an authoritative perspective, but just to show that there is a pattern of law enforcement officers using coercion to pressure victims of sexual assault who report to recant and then charging them with false reporting.
Your case doesn't have to go there. I mean, I don't think, it seems to me, it's an evidentiary question in terms of the use of the video. Typically in the pleading stage, you don't look at other evidence, but we do have cases in which if it blatantly contradicts some facts in there. So if I'm looking at this case, I'm thinking the issue here is, it does boil down to that problem about its determination, is there blatant contradiction? Then it goes to what is blatant contradiction? And it seems to me, your argument, at least the way I was read your briefs, and the way it seemed to point is that the judge didn't look at he didn't really analyze whether the facts were blatantly contradicted. He looked at the whole case and said, no, doesn't look like, this is it. No, that didn't happen, so to speak, which is really more getting toward a factual question down the line. So it seems like the issue here is pretty narrow to me, but I might be reading it too narrow. So tell me.
Well, we are in agreement. This is why I focused my reply brief also on this narrow issue, because it's really just a matter of the court is required to accept all of the factual allegations as true under 12b6 and accord all reasonable inferences to the
They
plaintiff.
went outside the complaint, though, and put this tape in, right?
That's correct, Your Honor.
And was it proper to consider that? That's what the question is, and it carried today.
So the idea of considering it, under Dorietti v. Sletton, this court recently had considered a video recording, also in a 1983 case. And similar to here, we did not object because we're not objecting to its authenticity. So it can only be considered under Dorietti to the extent, as Judge Wynn had just said, to the extent it blatantly contradicts the plaintiff's allegations.
You said there was no blatant contradiction.
That's correct.
So, I'm sorry, good.
No, you go ahead.
I want to make sure I understand, I mean, I understand that point, that you don't think this blatantly contradicts specific factual allegations. I mean, it may blatantly contradict one or two, but I think by and large, your argument is, Judge Wynn, I think, summarized rightly, is that the district court seems to have said, look, when you look at this audio, you can't really, no reasonable person would claim that is a coercive confession. And your position, I think, is that's not a proper use under Doherty or the Scott v. Harris, place that all came from to do something like that, because that's looking at the whole situation. And in fact, one of the factors in the coercive confession issue would be the individual characteristics of the plaintiff. And, you might, I think you said you would introduce evidence about that, how that you aren't in the pleadings yet. So I hear you. I'm not, don't take that other than at least I understand it. But you did say that you agreed to the district court that it could consider the audio recording. So it seems like it's not an error for the district court to have considered it. Indeed, you can't really say, that's okay with me, and now criticize it. But then you got to do it in accordance with the law. And your argument is that he went too far with it, basically. Is that fair?
Yes, Your Honor. Thus, it's very similar as to Dorietti, where this court clarified that considering it is one thing, but then the court went on to interpret it, which is what we maintain happened here.
It's like a trial to the court. It was like a trial to the court with limited evidence.
So what if we agree with you? That the district court, went further with that audio recording that he should have. You probably were sitting here, for the prior argument. There's this issue of other, can we affirm on other grounds, or was it harmful or harmless for the district court to have done that? And the defendants point out that there was at least qualified immunity here by the officers involved. First of all, what's your view if we agree with you on the coerced confession and the consideration of the audio? Can we consider that? Should we consider it? If we do, what's your position on it?
Well, at this stage of the proceeding, when there are material factual disputes, there should not be any consideration of qualified immunity. But going further than that, the sexual assault response policy that we attach to the pleading, in and of itself, creates an expectation of what the law enforcement officers should have done. And I recently learned, and I would ask the court to take judicial notice of this, that the Virginia Code 9.1-1301 requires all law enforcement agencies in Virginia to have a sexual assault response policy. So this policy was required. And obviously the inference there is that the Commonwealth of Virginia has some sort of expectation for law enforcement officers to be trained and to learn how to respond to sexual assault reports.
But, if we stay with where we are, we can make this case, expand it to different areas. Go back to Doherty, which is really the basis for the admissibility of videos here. And it says, first of all, it has to be integral. Well, that's not contested here, that it's integral. And then you agree it's authentic. That's where you get into that but part of Doherty. Doherty said, but it must show facts that are blatantly contradictory. That's the problem that I see with this case, and because that was not done. And I don't see how it can be harmless because he didn't do it. And that's the whole basis of using a video recording. If you go down and list every one of those facts in that complaint and compare it with what had happened on that video, there's almost nothing that contradicts. I mean, there's maybe a statement toward the end, I found, maybe on paragraph 77, where he said, I assured her that they would not tell anyone else about the incident. That's in the complaint. But then the recording says, I have to let the captain know, or I have to let the security people know. That's about it. I don't see any other facts in here that are contradictory, unless you want to look at a legal conclusion.
Right.
And say a legal conclusion is contradicted. In other words, no reasonable jury, as Judge Quattlebaum put, could come up with it. Then that's a whole different ballgame. But I think we expand Doherty when we start doing that, because Doherty tells you right quickly, you got three things there. Is it integral? That's not on the table. Is it authentic? That's not on the table because you've agreed it's authentic. But it doesn't show blatantly contradictory facts here. That's the problem that I see with this case, and it seems pretty straightforward to me.
I am in agreement with you, Judge Nguyen. In the district court's defense, I think that Judge Urbanski just viewed these facts in the frame of suspects in violent crime investigations and just sort of put it through that lens where thinking that these were legal conclusions that could be made. And obviously Dorietti was issued after the opinion, but prior to the 59E order. But I am in agreement.
Well, he may be right, he may be wrong, but even if he's right, that this would ultimately doom the complaint, and I know you wouldn't agree with that, and I'm not asking you to agree, but even if his assessment is right, I think is under our case law, if it's an assessment of the legal conclusion of the facts, that's different than a contradicting the factual allegations themselves.
But let's be fair to Judge Urbanski. He didn't have Doherty before him. That case wasn't decided, so.
That's right.
Because he's a very good judge, and I want to put him out of it, but.
Sure.
I think had he had it, he'd had a different analysis, more in line with what I've articulated here for today to court.
Well, Dorietti did come out between the memorandum opinion and our motion under Rule 59E, and perhaps he just didn't look hard at it. I don't know what occurred, but I share your agreement that he's a fantastic judge. So I just think if one were to look under the court precedent, the answer is clear, that you can't be, It doesn't sound like, are there any other questions? I don't mind ceding my time.
Thank you very much.
Thank you.
We appreciate it. You've saved some time if you need some rebuttal. Mr. Schnetzler,
Schnetzler, yes, Your Honor.
good to have you with us.
Thank you for having me. May it please the court, Nathan Schnetzler on behalf of the appellees, Sheriff Blake Andis, Jamie Blevins, Scott Atkins, and Brad Roop of the Washington County, Virginia Sheriff's Office. Your Honor, I'd like to jump to really where the discussion left off with my friend on the other side with respect to the question about blatant contradiction. And for me, that raises sort of two issues that this panel needs to consider. And one, I think the main question here is whether or not Judge Urbanski's determination that there was a blatant contradiction rested on the issue of a legal conclusion, or whether there was a blatant contradiction with the factual allegations in the complaint.
Doherty makes it very clear. It says, but only to the extent the video clearly depicts a set of facts contrary to the alleged in the complaint, or blatantly contradicts. It doesn't say that it gives a blatantly contradictory legal conclusion to it. So it seems like to me we're talking about the facts of it. Because when we start going other places there with it, then we really are getting into a jury determination, aren't we?
Well, Judge Wynn, I'm not arguing that it should be it can be based on a legal conclusion or a factual contradiction. What I'm suggesting is that this panel needs to consider, what did Judge Urbanski do? Did he say that there was a blatant contradiction based on the legal conclusions in the complaint, or did he say there was a blatant contradiction based on the factual allegations in the complaint?
So you are saying there are blatant contradictory facts here. What are they?
I agree with Judge Urbanski in his decision on the motion to reconsider, and this is at J 148. where he writes, he's quoting from the complaint. He says, in response to.
Which paragraph is he quoting from the complaint?
This is the paragraph 70 from the amended complaint.
Where you said it made an audible noise indicating agreement? And then you look at the actual audio and says, or something like that. Isn't that an audible noise indicating agreement? What's contradictory with that?
And he continues, Your Honor, because Bermeo did not think she had any choice but to tell Roop and Adkins what they wanted to hear. And he says the full paragraph demonstrates that Bermeo claims that she only.
Now, when he made that determination, where did he get that from? Because Bermeo did not, isn't that that's him.
That's an allegation in the complaint. That's the allegation. That is the direct quotation from the complaint.
And read it again. And that's on paragraph 70?
Yes, Your Honor.
Okay.
He quotes from paragraph 70, and after he says that noise indicating agreement with Roop, this is in paragraph 70, the second amended complaint, and I can pull the JA site for the second amended
No,
complaint.
I got it right here. You good.
The paragraph 70 then goes on to say, because Judge Urbanski inserted the plaintiff's name, because Bermeo did not think that she had any choice but to tell Roop and Adkins what they wanted to hear, Judge Urbanski modified just to include the names of the defendants.
So where's the contradiction in the audio?
According to Judge Urbanski, his interpretation was that she only agreed with Roop because she was coerced, and he says that is a suggestion which is blatantly contradicted.
What is it? I mean, where is the contradiction in the audio?
That she made the statement because she didn't think she had any choice. Therefore, meaning she was coerced. The inference there is that she was coerced.
I'm not following.
But
I'm trying to understand. You got the complaint saying one thing, and then in order to get there, you need something factually from the complaint. I got the conclusion and an interpretation that Judge Urbanski and we all can make, but where is the direct contradiction to that statement in paragraph 70?
Here's another way to say it. Does the audio say, did Bermeo in the audio say, I did think that I had a choice about telling Roop and Atkins what to say?
No, it doesn't, and that's where I was trying to get earlier.
But I think that's the issue. That's the facts. The facts are that Bermeo says she didn't think she had a choice. And the audio in the audio, she doesn't say, I did think I have a choice. What the district court did was looked at the audio as a whole and said, I think that statement is not supported given the audio as a whole. Would you agree with how I described it?
That factual allegation that's not in the recording is not supported by the recording, correct?
That's different than contradictory.
Yeah.
There's a lot of things not in that recording. And every time she says something here, that the standard is not that it must be supported by the recording of audio. It needs to be contradicted by it. So it's not the absence of her saying something, it's the fact she didn't say that on there.
Not just contradicted, blatantly contradicted.
Correct. And again, I want to go back to my initial suggestion is that if we're talking about, if Judge Urbanski was wrong and decided that he felt that the audio recording blatantly contradicted that Bermeo was coerced during this interaction. If that is not a factual contradiction, I think we have an issue with a legal conclusion.
Okay.
And so then this whole issue about whether or not Judge Urbanski considered the recording really becomes a non-issue, because we moved on the grounds that regardless of the recording, the factual allegations taken as true were not sufficient to establish as a matter of law that Ms. Bermeo was coerced into making this confession.
Taking it as true, she said she didn't think she had a choice but to do this. Your point is, well, you didn't say that on audio. That's not the standard. I mean, it cannot be. I mean, otherwise, what is 12b-6? If you can come back to something that's in opposite to if you don't have something in opposite but something you say in a complaint in the video, then you can come back and says, well, that is not true, you would have said it, or something of that nature, but you didn't say that. That doesn't follow. I mean, it really muddles it to me. And, you know, bringing it down, I mean, we get in the whole business of, as I said, bringing in extra evidence during the 12B6 stage. Typically, you don't do that. You stay with the pleadings. There's a limited way in which we bring in videos. It's happening in circuits have begun to allow them, some not so much so, probably for good reason in cases of this nature. But when you have a case where you got all these facts, and then you got this video that everybody says is authentic, and it is integral. Authentic is very important in this day and age with A&I. You got to make sure that is what it is, and they say that's what it is. And if you said this and the video shows no, it didn't happen, this didn't happen, there have been cases in which there has been that blatant contradictory. This doesn't seem to fit in those kind of cases where that blatant contradictory fact is illustrated or shown or demonstrated by the audio.
And Judge Wynn, and if that is the court's decision, again,
No,
this.
I'm not trying to,
Well, no.
I'm not deciding, I'm just saying that's the law. That the law is Doherty, and Doherty sets it out very clearly. It must show blatantly contradictory fact. That's not a decision. That, we just follow what's there.
If I understand what you're saying, for the sake of argument, assume error because the district court went beyond using the video to deal with blatant contradictions and assessed it with legal conclusions. You're saying, even if that was erroneous, you still think the pleadings don't properly allege the claim she asserts?
Yes, Your Honor.
And now, we don't have that. I mean, that's an alternative basis for us to decide this appeal. Is that what you're suggesting?
Yes, Your Honor, there are multiple bases.
So you're arguing harmless error?
Yes, if there was error, it was harmless, and that there are alternative grounds.
We usually hear harmless error in criminal cases from.
Really, what it is in the civil
But
context.
you're arguing it in I guess it sometimes applies in the civil context. So that's what you're arguing now, today. You're here arguing harmless error.
It's a nuance of it in the sense that this
you-
court can reverse for grounds that are
So you
before it.
confess error and say it's not prejudicial.
I'm not conceding error, Judge King.
Well, you're arguing harmless error, you have to.
You can't argue harmless error unless you admit the error.
But the appellee is allowed to argue in the alternative that even if there was error,
So
there are alternative grounds.
you're hypothetically confessing the error.
Yes, Your
Is
Honor.
that what it is?
Hypothetically, if there was error, there are alternative grounds to affirm.
Well,
I thought you said there was error.
I did not say that there was error,
Judge-
Judge King. I'm sorry if I
I
misspoke.
thought you said that to both my colleagues.
yeah, I understood you to
I was
say,
just sitting here listening, and that's the way I heard it.
I'd
Why
like
don't
to,
you get away from using harmless error? That's not really what you need to do. 12B6 only requires you to look at the pleadings. And it seems like then you are saying, well, even if you don't look at the video, or if you don't consider any of the video, you're saying on the complaint's face itself, it fails to meet the 12B6. Is that where we are? I don't know if the word harmless error needs to go there, because then you're gonna find yourself where you are.
Yes, Your Honor. Judgment, and we did not argue harmless error. Again, we argued that there are alternative grounds for affirmance in this case.
Well, that's not an alternative ground, that's the ground. If 12B6 says, look at the plea, you say, forget the video, take all the video stuff out, and on the complaint itself, it fails 12B6. Doesn't sound alternative to me, it sounds like that's 12B6. You bring in the video because if the video helps you to get there, with Doherty, you can bring it in if it shows blatant contradictory. But you're saying you don't need it, as I understand, you don't need to look at the video, just look at the complaint itself. And so when you get to the complaint itself, your argument flows from there. It's the way I see it, maybe I'm not hearing it, but that's why I say I don't think harmless error needs to be brought up, because that's 12B6.
Correct, Your Honor. I think what we need to talk about is what
You
is the test for
brought the video
coercion?
into it, didn't you?
I'm sorry, Your
You
Honor?
brought the video in.
Yes, we submit, well,
So you're saying now you don't need it. You're repudiating the video.
yes,
Is that
Your
what
Honor.
you're doing?
Yes, Your Honor.
You withdraw the video.
Yes, Your Honor. I
If you
withdraw.
can
I don't
do
want to
that-
consider any
If you
further.
can do that now, but it's in the record.
You put it in.
counsel, tell us, Do you mind telling us, can we hear your argument about why you think, irrespective of the video, you prevail on the allegations in the complaint?
I would love to, Judge Quattlebaum. First and foremost, there is a critical issue in this case where there, I believe, has been waiver by the appellant with respect to the briefing in this case. We raised substantial arguments in our opposition brief that simply were flat out not responded to in a reply brief. This court has found that to be tantamount to waiver. That was in, I believe it was the Mahdi versus Sterling case, 20 Fed 4th. The pin site is 905 at footnote 42. And again, so there, we raised a number of arguments, but one, as Judge Quattlebaum brought up during the opening
Let me
argument.
process this, because again, it's the process we're going through. We're on 12B6, which is basically you look at the pleadings themselves, and Iqbal and Twombly, to determine whether or not these allegations are there sufficient. And when you get into whether or not you waive an argument to us or not, what's our review? Are we de novo review on the 12B6?
Yes, Your Honor.
So we just look at the complaint. And to Judge Quattlebaum's question, that's where your argument should go. What in that complaint makes it deficient to the point that, as a matter of law, it must be dismissed under 12B6?
The test for coercion is the totality of the circumstances test. It's not just the subjective belief of the plaintiff, or in this case, a criminal suspect or a defendant. It's the totality of the circumstances. And so if we look at this totality of the circumstances, we have, on the one hand.
Totality of the circumstances as reflected in the complaint.
Yes, Your Honor.
So it has to, the complaint has to fail to state a claim upon which relief could be granted.
Yes, Your Honor. And so in this case, we have a 21-year-old woman who is a high school graduate. She is a double major at her college. She's attending college as a double major, and there's some sort of, I think, criminal justice major as well as a psychology major. This interaction did not take place inside of a sheriff's office, did not take place in the context of a custodial detention. She was not handcuffed. There was no suggestion that she was not free to leave at any time. It lasted 24 minutes.
What was the criminal proceeding in related to this?
After this interaction, where Ms. Bermeo claims she was coerced into confessing to making a false report,
Yeah?
she was subsequently charged with making a false report to law enforcement.
And she was acquitted.
After she was convicted by a general district court judge.
And she was acquitted.
Yes,
There was a retrial and she was acquitted.
yes.
What's the effect of the acquittal?
It's irrelevant for purposes of the coercion analysis.
So is your, you cited some facts during the complaint about her adult status, her educational status, the length of time, the, where they were when this happened. And those, I think, under the complaints are part of the totality. Do we, but the subjective viewpoints are part of those totality too. You're not saying that's irrelevant, right?
No, Your Honor.
So that's part of the totality. And what's not, and this isn't in the complaint, but there, you know, what I wonder about, given that we have allegations about the subjective belief, which, you know, is relevant, given the fact that you have facts that you think support that there's not coercion, you know, can we say, you know, at this point that there's absolutely not a legal claim? I mean, even the nature of totality of the circumstances is you know, some people don't like those tests because you never know whether you have it or you won't, or you don't. But, you know, can we say at the 12B6 that there's just not a claim supported there? It seems like we got facts in there that would point your way, allegations that she would point the other, that would point the other way. How can we do that at 12B6?
You can, Your Honor, because very similar to how this issue would be looked at in a criminal context. For example, in the cases we cited, United States versus Braxton, the Whitfield case, which Judge Wynn was on, I believe, when the Fourth Circuit is reviewing those issues where a district court has made a determination about coercion in the criminal context, it has to take the factual findings of the district court it can't question them unless they're clearly erroneous. And so it's very similar to taking the allegations in the complaint as true as to whether or not, in this context, they state a claim where, as my friend on the other side has said, all of her claims sort of rest on this notion of coercion. And so if there was no coercion, then there would be no basis for any of these claims. And so that's how the court can reach that issue.
But we'd be doing something, and you know, am I right on this? We'd be doing something which is looking at that complaint in its totality and deciding whether it was sufficient. We'd be doing that in the first instance, because under this hypothetical that it was wrong to consider the video or audio, the district court didn't do what you're suggesting we can do. You're saying, and I don't think that's an absolute, I don't think that means we can't do it, but we'd be the first people to do that analysis.
Yes, and this court has done that very thing multiple times in multiple cases where a district court judge has ruled.
Yes, I thought you said, he said you'd be the first time, then you said yes, and then now you said we've done it multiple times.
I meant in this case.
Yes, Judge Quattlebaum, in this case, it would be the first time, but this court has, on multiple occasions, affirmed district court rulings for alternative grounds that exist in the record and arguments made by the appellees.
Does the issue of qualified immunity come into play? I mean, because one argument would be that you haven't pled a coerced confession, and these are 1983 claims. Would an argument be that even if there's some question about that, there's no clearly established law that would say the right, as it applies in this circumstances, is clearly established?
Correct, Judge Quattlebaum, because there hasn't been, at least that I have not been able to find a case involving an interaction with a person who is not in custody outside, no question or suggestion that they were not free to leave or that they were physically abused or any of these or lacked mental capacity or ability to understand what was happening. Any suggestion like that, such that these officers, and that's where qualified immunity comes to a head, is there has to be some case that at least is somewhat similar on the facts to determine whether or not that right was clearly established at the time. And again, this is 2020 when this happened. So
y'all briefed that below?
Yes, briefed that below.
And you briefed it to us, but the district court didn't rule on that?
The district court did not address it because it reached ultimately it ruled as a matter of law there was no coercion, and therefore the claims failed for that reason, as well as some additional reasons that the district court raised that we articulated on brief as well.
Okay.
I see that I'm out of time Thank you, Your Honors. We would ask that the decision be affirmed.
Thank you very much, sir. We appreciate it. Ms. Hordachuk?
I don't have much of a rebuttal to add. If Your Honors have any questions to follow up.
What do you say about this qualified immunity assertion?
I would say, and again, I know I didn't say this was authoritative, but that Third Circuit opinion that I sent in the 28-J letter, Reedy versus Evanson, they address qualified immunity in this context and mention that the intention of qualified immunity is to support law enforcement officers in split-second decisions, and it's not
We understand some qualified immunity. Were they claiming qualified immunity for the alleged sexual assault or for the coercion on the statement?
They're claiming qualified immunity, like saying that they didn't know that coercing, or I don't know if they're saying that's not coercion, but they didn't, what my understanding is, They're saying that they did not know that their actions in interviewing this victim of sexual assault was unconstitutional.
It was qualified immunity with respect to the interview.
Well, with respect to,
Is
it's
that the
really
claim,
probable,
as you understand it?
probable cause, I would say, is really where it comes in.
But they're talking about qualified immunity for what they did, for the police officer.
Correct.
And to follow up on that, I mean, you know, we can assess that, you know, ourselves. I think we have the authority to do it. We have the authority to send it back and ask the district court to do that in the first instance. You know, not to, you know, say for sure, but it's kind of hard to imagine, quite frankly, us sending it back and, you know, just based on the order and not know what's happening. The district court's made this pretty clear, but anyway, I guess that's just a decision for us to make.
Well, we ask that the court please reverse and remand, vacate and remand. Thank you.
Thank you very much.
And we're going to come down to Greek Council, and we're going to take a break and have a conference between the judges, and then we're going to come back in and talk to the VMI students for a few minutes, Madam Clerk. So for now, we'll take the break from the Greek Council.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable